everyone, and welcome back to the Immigration Insights podcast. My name is Kate Kalmykov, and I co-chair the Global Immigration and Compliance Group at Greenberg Traurig. Today, I'm very excited to introduce my partner, Kara Bombach, from our Washington, D.C. office, where Kara chairs the International Trade Group. We're going to have a very interesting and timely discussion today about export controls, sanctions, outbound investment restrictions that are coming, as well as the impact of a Trump presidency. So, Kara, can you please introduce yourself to our audience?
Yes, thanks, Kate, so much for having me. Happy to be here. It's always fun to talk about sort of these intersections that we have between the trade practice and the immigration practice. So I'm looking forward to it. As you mentioned, I chair our international trade practice here in Washington, D.C. As a group, we really have sort of a full service trade team dealing in trade remedies, imports, exports, outbound trade, and also national security reviews of inbound investment into the United States. And my personal practice focus is more on the outbound trade, and then those national security reviews. So I'm happy to dig in on those topics with you today.
Thank you so much. So let's get right to it. Let's talk about export controls. What are they? When do they apply? What do employers need to know?
Well, from a U.S. perspective, we have essentially two different agencies, for the most part, that are regulating exports: the Department of Commerce and the State Department. The Department of Commerce is regulating exports of items, which are goods, software, or technology, and generally in the dual use space or the commercial space. The Department of State, on the other hand, has jurisdiction over defense articles, military items, defense services, and they have their own licensing regime and their own enforcement regime. Both agencies view exports as the physical export of an item, the goods, service, or the software or technology from the United States to a destination outside the United States. But they also have the concept of what we call a deemed export. So a deemed export is actually the release of technology or even providing access to controlled technology in the United States to a non-US person. The definition or sort of the concept of who is a non-US person in the United States, essentially it's anyone who is not a US citizen, a lawful permanent resident, or someone who's been granted refugee or asylum status in the United States. So while someone may be authorized to work in the United States under different categories of visa, they're not going to be considered a U.S. person for purposes of the export controls, and release or sort of providing access to controlled technologies would be considered something that could require a license and definitely would be an export.
So let's expound on that. When should a company be aware of it? Because I may secure a work visa for a non-US person. I do that all the time. Either they're coming here and they're getting work authorization through employer sponsorship, sometimes through family sponsorship, whatever it is. They're still not a permanent resident, an asylee, a refugee, or US citizen. They're a non-immigrant visa holder, or they're simply an alien who is work authorized. What does a company need to know when they're bringing them on board?
It can feel a little chicken and egg because certainly as part of the immigration process, you're thinking about how are we staffing, what are our needs, who are the qualified individuals to sort of fill these different roles, or where you have executives that may be sort of moving between different entities in a corporate family and things like that. From the trade controls standpoint, we want to know as early as possible, because there are some kind of extreme situations where the export controls could actually very significantly impact the whole purpose of the move or the way that a company might want to staff a particular project. So the sort of most extreme examples would be situations where you have a technical expert, an engineer, someone who actually really needs to have access to, would be involved in the development, but also would need access to export controlled technology, whether it's software or specifications that they're developing, or maybe even that the company receives from its own customers, where they might be doing sort of a design to specifications or build to print. If that if that candidate is a national of a country that's subject to an arms embargo, and the license that would be required for giving the person access is something that's subject to the State Department jurisdiction, where we're talking about some sort of defense articles or parts and components or things for defense articles. Not only is a license required from the Department of State, but it's impossible to get a license because the State Department is prohibited from granting it due to the arms embargo. So you could get into a real sort of conundrum where you have identified a candidate, you want to staff them on a particular project, but there's no way that you can even get the authorization for that person to actually participate the way that you want them to in the particular project. So sort of backing down from that particular example, there are others where it won't be sort of a blanket policy of denial or an embargo where the license can't be granted. But there might be situations where a license is required. And then if a license isn't sought and obtained prior to giving that person access, then the company is actually in a position of having committed a violation of the export control laws. And the export control laws, both on the Commerce Department side and the State Department side, are subject potentially to civil penalties, administrative penalties, and criminal penalties in the case of very egregious sort of willful violations. And then there's, kind of a ripple effect of other consequences, things that can happen, like impact on U.S. government contracts or the ability to be a U.S. government contractor, certainly reputational issues, and then, the kind of snowball effect that can happen for internal investigation or things when something like that happens. So it's definitely preferable to be thinking about the export control issues basically from the moment that you're figuring out how to staff a project. To understand, because there is some analysis to do, not only on the nationality and sort of destinations involved with the candidate, but in many instances, there's some need to do some analysis on the side of what is the technology, what is the appropriate export classification of the technology they're going to be involved in or that they might need to have access to. And particularly in situations where maybe there haven't been non-US persons staffed to that project before, it's possible that no one's ever done the analysis. And so again, we're thinking from the standpoint of what does the foreign person require access to, or what would they be given access to? It is not limited to what is the product or the service that the company generates and has commercialized and is selling to its own customers. Sometimes we get into that discussion as well, where a company thinks, or sort of is of the mind that, well, the things that we sell to our customers, we don't think that they're subject to export controls. And that's helpful, but there may be tech that's being used in order to generate those things that is subject to export control. So we kind of have to go back a couple of layers just to kind of piece that together.
So it's critical that employers are contacting you at the outset. And I think it's important to us as immigration lawyers that we're also aware of this so we can flag it for our clients, because we don't want to get into the process, secure a visa approval, and bring someone here, and now have the employer subject to sanctions, as you discussed, investigations, and the employee is not going to be in compliance with the conditions of his visa. Mm-hmm. So what countries are under arms embargo? Can you give us some examples?
The longest and probably the most impactful arms embargo is actually against China. And so that can come up very frequently in staffing of different projects. I mean, it can come up in not just in the sort of the commercial context, but in, university research and sort of collaboration, joint development projects and things like that. I would say that is primarily the most significant arms embargo. Just speaking kind of more broadly, the countries that the U.S. targets with comprehensive sanctions, whether that's sanctions administered through export controls or arms embargo, or economic sanctions that are administered by the Treasury Department. Right now, the comprehensive sanctioned countries are Cuba, Iran, Syria, North Korea. So certainly any nationals of those countries, we would really want to take a very close look sort of at all aspects. Is there any aspect of even the sort of hiring and engagement process that might trip into any kind of sanctions issues? And not so much necessarily on the immigration side itself, but we do see this frequently, in certain contexts, where there might be candidates of a particular nationality, or even from a country where they're fleeing, where they're trying to maybe even defect, and there may be some role of agents or representatives or people who just really want to help and to assist this person in the process. And every sort of movement in that chain needs some scrutiny and some compliance mechanisms to make sure that, even with good intentions, there isn't sort of an inadvertent tripping into some sort of sanctions violation.
Yeah, sanctions issues are actually very interesting because they differ country by country. The sanctions regimes are different, as I found out in the immigration context. And, they can be far-reaching in certain cases, as you just described, to third parties or even third countries, right?
On the question on sort of where in the process should companies be looking at whether there are export controls or export restrictions on a particular candidate. My understanding is that, at least on the immigration side, there's a little bit of a checklist or a preview for this in the completion of the I-9 certification. So that, I guess, and I'm kind of throwing a question back to you as well here, that in completing the questionnaire, there's something that asks whether the candidate would require access, or in doing their job, would they need a license from the Commerce Department or the State Department? And so in order to be able to make that conclusion on sort of which box to tick, it's really important to have done the analysis ahead of time. But then also to be thinking about going ahead and applying for the licenses. Because that's the other thing to take into account, is just sort of the delay or the process in how long it might take to actually get the license granted. So you could also get into a situation where the immigration process is moving smoothly, the hiring process is moving smoothly, certifications are all filled out correctly, and then you're ready to get the person going to work to dig in, but the license hasn't been either sought or granted yet from the agency. So it's important to kind of have that timeline mapped out pretty early on.
Absolutely. And obviously, the I-9 is the form that every new hire in the U.S. under the Immigration and Reform Control Act of 1986 has to complete. And, ICE, which is the enforcement arm of the immigration agency under DHS, has been very active in auditing. And they're also working very closely with other agencies. So we see that obviously with DOL, most commonly the Department of Labor, but when there's sensitive technologies, we see that as well. So there's a lot of communication, and employers can be subject to sanction, as you described, under the trade requirements, but they might also be subject to sanctions under immigration requirement. And really, there's a lot of exposure with this one-page form that people don't think about. So let's talk about inbound investment into the United States. I'm an immigration lawyer. I deal with companies all of the time, expanding operations in the US, transferring personnel. We work with investors and entrepreneurs who maybe even come to the US to do a startup. And they're coming from all over the world, including China, Russia, Iran, places that, are sensitive. So there's different visa categories available to them, and no national of a particular country is banned from applying for a visa. They may be subject to more rigorous background checks, and we do expect that under a Trump presidency, starting in January, that the background checks are definitely going to become more rigorous. He's already said that's going to be part of his policy, especially for people that come from countries that are state sponsors of terror. But what are the implications for CFIUS? What is CFIUS? You deal with a lot of acronyms, and I think that's why we get along, because as an immigration lawyer, I do too. So what do employers need to be aware of here with inbound investment into the US?
You definitely hit all the points there on the sanction side. I think, when we're looking at investment into the United States, that's sort of, from the Committee on Foreign Investment in the United States perspective, and that is the committee that is paired through Treasury, but is actually a committee of at least 15 different U.S. government agencies who are reviewing different kinds of inbound investment for national security risk. So, understanding the nationality of the investor is primary to figuring out whether there are national security risks, or even, as a private practitioner in the space, if we can anticipate what we think the government would view as a national security concern. There could be, just right off the bat, sanctions issues with investment from a sanctioned country or from a national of a sanctioned country. And that would be the economic sanctions measures that I mentioned that are administered by the Treasury Department. The other piece of this under CFIUS is that any foreign investment into the United States potentially is inbound for review by the committee. And in the background is the legal authority that the President of the United States has to actually block or unwind investment or transactions that pose a national security risk. So the committee, there are certain types of foreign investment that trigger mandatory notice requirements to CFIUS, but the vast majority, which is a much kind of broader scope of investments and transactions, are not subject to mandatory declarations or notifications, but are in scope for what we refer to as voluntary notification. The benefit, or sort of the reason why someone might choose to do a voluntary notification, are, one, because at the end of the process, assuming there are no unmitigated national security issues, the companies, both the target and the investor, receive a safe harbor letter from the Treasury Department, from the committee, that says, we do not see any unmitigated national security risks. Therefore, proceed. And that's, a nice sort of warm, fuzzy feeling for everyone involved in the transaction, that they're not going to face the risk of it being ordered to be unwound, or some divestment order down the road. There are, I would say, a number of very savvy foreign investors who really appreciate having that safe harbor letter. And so they've just sort of made it their routine for when they're investing in the United States that they're going to make a notification to CFIUS. The other aspect of this is that over the last few years, there has been a pretty significant increase in budget allocation, staffing, resources within CFIUS, where they are actually taking proactive, investigative approach in monitoring press releases, securities filings, anything that's sort of out in the news about particular investments and transactions, because they will come ask questions about transactions if they haven't been notified. So we call those non-notified transactions. If CFIUS learns about it either through their own diligence and research, through a competitor who maybe picks up the phone and calls CFIUS and says, hey, we think that there was this foreign investment that maybe creates a national security issue, then, they will come asking questions, and they can actually request or compel parties to make a filing. And so again, this is just another it's sort of an export controls adjacent topic where it's really important to be thinking far ahead in the deal timeline, or even as the very initial stages of the investment even being considered. The other notes that I like to point out on this topic are that historically, CFIUS was concerned with what they call control transactions. So where a foreign person would actually, the transaction would result in the foreign person having control of a U.S. business, of these U.S. assets, whatever it might be. A few years ago, the statutory landscape and the regulatory landscape changed and broadened the scope of transactions that are in scope, including even in some instances, minority investment. And it could be minority investment plus some indicia of control, but as minimal as an observer seat on a board. So observer seat, a board seat, decision-making right, access to certain kinds of non-public material information or technology of the target business in the United States. Those would all be triggers for a deal being in scope for CFIUS review. And in some instances, depending on the nature of the target, subject to mandatory notification to the Committee on Foreign Investment. And so again, in addition to this sort of risk of having a deal blocked or unwound, there is also the potential for civil monetary penalties up to effectively up to 2 times the value of the investment in the case where a mandatory declaration is not filed. So again, it's sort of, taking the long view of the checklist of things to consider on inbound investment. This kind of triage to figure out if the deal might arguably be in scope for CFIUS is really important.
So it's critical to bring you in at the beginning of any such sensitive transaction. And have there been big company transactions like this that have been unwound? Obviously, I think a lot of us see in the news threats to unwind social media apps that are controlled by the Chinese government or by Chinese companies. But has any of that actually occurred on a large scale?
So what I can say is it's not rampant, but there definitely are instances where there have been divestment orders or requirements, and some of them are very public. Some of them are not so public. Sometimes what will happen is in the course of a transaction, either the parties realize sort of a little bit late that they should notify, or that there's a risk, or CFIUS comes asking questions quite before all of the transaction has closed. Maybe it's in a certain phase, and they may make it a condition for approval to essentially restructure or mitigate this national security risk by divesting portions of the target or requiring a divestment to a U.S. buyer or a buyer from a jurisdiction that's, or by their identity, a buyer that creates less of a national security risk in the eyes of the committee. So it definitely does happen. It's not sort of this, threat that's looming that's never occurred. But I would say that for the most part, those are reserved for the situations where they are very significant transactions, and really the parties and the government have gotten to a point to say the only way really that the national security risks can be mitigated is to have a divestment. There are lots of other mitigation measures and approaches that can be put in place. And, part of what we like to help clients with, whether we're representing the foreign investor or the target for the investment, is to think about strategically what the national security concerns might be. And are there things that could be done ahead of closing, maybe even ahead of the notification to CFIUS, to mitigate the national security risks? So That can be through, implementing certain kinds of policies and procedures, or silos, or in instances where the U.S. business perhaps is, holds a security clearance and is doing classified work for the U.S. government. That would require things like um, mitigation, where the cleared entity basically comes under its own little umbrella, and the foreign investor is going to be restricted access and potentially even restricted decision-making rights and things relative to that piece of the business. Or, some of the mitigation can be maybe one piece of the target business shouldn't be part of the deal. Maybe you just shouldn't even bother because it's going to, it's either not going to clear through CFIUS, or the costs of the mitigation measures will essentially undermine the value of the transaction, or, not be worth it from the business perspective.
Super fascinating. Now I want to go back to OFAC and Treasury and the sanctions. So we at GT have a robust EB-5 investor practice where someone invests a certain amount of money, either $800,000 or $1,050,000, in order to get a green card, and they're investing into a U.S. business. So in this case, the investor is foreign. They typically put money into a fund. The fund then typically either loans or provides equity to a commercial real estate project. Now, we represent nationals from all across the world, and obviously we know that certain countries are under sanction. So when can we represent those individuals? Who's allowed to invest in the United States? And what is an OFAC license? And when can we get it?
Well, these are, every time we have one of these questions, I feel like it's a throwback to the most, confusing, convoluted law school kind of exam questions that we could have. We'll just throw a lot of variables in, but that's what makes it interesting. So really, and you alluded to this earlier, every one of the sanctions programs that the U.S. government implements are slightly different. So there's not sort of a one size fits all across the board. I mean, there might be some consistency across programs, or a similar approach in sort of definitions or application of concepts. But we really have to go look at not just the sanctions program for the particular country, but make sure that we're looking at the latest and greatest, because potentially, actually, even more than the export controls, which are very dynamic, the sanctions are incredibly dynamic. And it's all inherently tied to foreign policy. And the president of the United States actually has legal authority to impose sanctions very quickly, with almost no notice, by executive order. And then those get implemented by the relevant agencies, usually the Treasury Department. And that's, the dynamic nature of the sanctions is almost by design, because one of the major risks, or one of the mechanisms from a sanctions perspective, is the blocking or freezing of assets that are in the United States. And so if the U.S. government decides to target a particular individual, if they give much warning that a blocking order is coming, then there's the risk of asset flight. Think money is getting moved around, assets, things getting divested, and things like that. So they're very dynamic. We need to check sort of the latest and greatest, because they're not only are there executive orders issued frequently, but the Treasury Department, the Office of Foreign Assets Control, issues FAQs. They issue general licenses, which are basically, kind of an across the board, if certain criteria are met, they can be utilized by anyone, where there would otherwise be some restriction or prohibition. So we look at the sanctions program. We look at the circumstances also of the investment. You mentioned that frequently these are investments that are made through funds. So now here's where it sort of, intersects. From a CFIUS perspective, there are certain exceptions or carve-outs for investments through a U.S. fund. So if we have a U.S.-based fund with a U.S.-based manager, general partner, decision maker, having some non-U.S. investors, even from a sanctioned country through an EB-5 program, may be outside of scope for CFIUS. But again, that's pretty fact specific because we're looking at how many limited partners are there, how many investors are there, what's the nature, do they have any decision making or access rights that come along with that investment or not. So it's really sort of, you know, all of those issues tangled together that we try to parse out.
Absolutely. And you've been incredibly helpful to us and our clients when we've needed specific OFAC licenses. We know we can come to you. And when we can't even represent an individual because maybe they're a specially designated national, we come to you and you let us know that. And people don't even realize what countries sometimes are sanctioned. Like Ukraine still has a sanctions regime that was implemented under the first Trump administration. So we have to be cognizant of that, even when we're preparing the immigration application, because USCIS, again, talks to Treasury and they will let us know. And the banks that receive the funds are also doing these OFAC checks, right? So they may not even be able to take funds from somebody who's an SDN or from a country where, you know, perhaps they can't transfer funds through a certain financial institution.
Absolutely. And I think, you know, you bring up a great point that the sanctions programs that are administered by OFAC, we have these country sanctions, but the vast majority of sanctions are targeted. So targeted meaning at a particular entity or individual. And there are specially designated nationals, these, you know, people or entities that are targeted by sanctions all over the world. Every country, really, in every country of the world. So the sanctions compliance almost can't, you know, it can't be limited to a country focus or a focus on embargoed countries or the comprehensive sanction countries, because we could have issues with a sanctioned person really in any or from any jurisdiction. And as you mentioned, you know, there's sort of the ripple of, you know, at the heart of it, do we have an investor who is potentially a sanctioned person or from a high-risk jurisdiction? And then what about the financial institutions or other advisors who are in the mix who you know, either themselves need to be screened from a sanction standpoint or may have their own compliance programs and policies that say we take a very conservative approach and we don't actually even engage in transactions with entities or persons, you know, in a particular jurisdiction or region. So yes, it can be quite thorny, but you know, in the process for getting OFAC licenses when they are needed, the process is fairly clear what needs to happen. It is the process itself is pretty slow because OFAC is a relatively small office for their mandate. And so that's another piece to kind of factor into the timelines and priorities is just how long the licensing process could take and what's the likelihood of success.
Absolutely. That's very important. Now, let's talk about outbound investment because you and I were recently talking and you let me know that there's these new regulations that are currently in the works and that there's going to be an outbound investment review regime to which seemed very counterintuitive to me. So tell us a little bit more about that.
So this is a U.S. outbound investment regime that is going into effect in January of 2025. This is actually the result of years, like more than 5 years of bipartisan efforts and support in Congress, executive branch. This has really been sort of a long time coming. And I think for those of us in the CFIUS space, we've expected it. We just didn't know exactly how and when it would arrive. If it was going to come through executive action, if it was going to come through an act of Congress or some combination. So over the last couple of years, there have been notices of proposed rulemaking. We've gotten sort of sneak peeks at regulations and sort of how this is going to work. And then just last month, then the final regulations were issued. So we know now what the program is going to look like when it comes into effect. The sort of broadly speaking, this is the outbound corollary to CFIUS. So the idea being US review or restriction on outbound investment from the United States to certain target countries or regions in certain sectors where we think that US investment could be either intentionally or inadvertently supporting the development of sectors in these countries and these regions that actually create a national security risk to the United States. So it's really an effort to close some gaps between export control restrictions that would restrict releases of controlled technology or exports of items to destinations and the national security review on inbound. This is to get at this issue of, are we sort of unwittingly, is a US investor unwittingly supporting development of technologies and capabilities outside the US that threaten the United States? So what we know right now, and sort of the current iteration, is that and I should say too, this outbound investment regime is not administered by CFIUS. This is actually standing up an entirely new, distinct office to administer the regulations, to review notices that are submitted, and to enforce the provisions as well. So one of the other ways that this differs from CFIUS is that there are some transactions that are reportable. That's somewhat similar to CFIUS. But under this regime, there are actually certain types of investment that are prohibited. So if a US person were to go ahead and conclude a particular investment, they could face liability through the enforcement mechanism on these outbound investment review. The countries or the regions and the industries that are in scope right now, this impacts US investment into China, Hong Kong, and Macau, and particularly in three sectors in AI, quantum computing, and semiconductor industry. So it's fairly narrowly tailored at this point to those destinations and those sectors. But it's also important to note that the restrictions and the reporting requirements would also apply to US investment into third countries, into companies in third countries that have 50% or more ownership or other sort of indicia of control from China, Hong Kong, or Macau. So this could impact JVs in third countries, or subsidiaries or things like that of Chinese companies. So again, it's we're because it is new, we're developing our toolkits for the best ways to kind of triage these potential investments and help clients figure out, are we in scope? Are we not in scope? Is this something that could create a risk for us? Is there a way to mitigate any of the risk? So, we're basically, getting into a position here that we can help triage and just assess these kind of investments. But it's another, in the large sort of multinationals or even very discrete, family office kind of strategic investments. This is something that could be in play really for any type of investor.
It's fascinating. I mean, I could potentially be investing in Brazil, for example, and they have a lot of Chinese investment, and unknowingly trigger this new outbound investment regime.
Absolutely.
So that's fascinating.
Yeah. Yep.
So to wrap up, Kara, I'm going to ask you to look into your crystal ball and tell me, and our listeners and viewers, what does the Trump presidency, beginning in January, look like for all of the things we just talked about? Are we going to see an expansion of these things? Is there going to be a different focus? Is anything going to change? Is it going to become more robust?
So, yeah, I mean, from my perspective and sort of, the crystal ball approach here, I would say really we can expect that China is going to continue to be the primary focus on trade policy, whether that's through export controls or outbound investment restrictions or inbound investment restrictions or imports, tariffs issues. I would say really, any touch points with China, even these indirect ones, like you mentioned, and a potential investment in Brazil or importing product from Mexico. Is there a China nexus a few layers away? Because that could start to become even more of an issue than it already is. From a sanctions perspective, I think, it's very tied to whatever is happening in the world at a given time, and the measures can be implemented very quickly without much warning. If I was guessing, I would say the potential for increased sanctions relative to Cuba, maybe also relative to Venezuela. That's again very much a watch this space, and maybe some other economic sanctions type measures on particular companies or people in China or Hong Kong or Macau. I think that's going to sort of continue to be the theme. I think that there is probably going to be some impact on the USMCA, which is really NAFTA 2.0. The USMCA is up for review in 2026. There are a lot of policy experts and trade agreement experts, not me, but our very smart colleagues, who are expecting that maybe even that review would start in 2025. Now, I don't know if that would be impacted by the Trump administration, or, it's possible that the Trump administration could try to just toss the whole USMCA, which was sort of the approach with NAFTA originally was, it's not NAFTA anymore. We're going to make this new thing. So we could have a little bit of a more dramatic shift or overhaul or renaming on that front as well. Just in general, I would say it's going to be very dynamic. I think there will be a lot of changes. And so we're just, all going to kind of have to work together and be prepared and stay agile and kind of keep up on the changes. So we're, happy to support you and the friends of GT, however we can do that. But we're gonna be, drinking our water and taking our vitamins to head into 2025 here.
Absolutely. Well, thank you so much for sharing your insights. They're fascinating, super important to our clients. And I think it's amazing that, at GT, I've been here close to 20 years, that we have this platform where we have all sorts of expertise in the law, and people in many cases, they operate in the immigration space in sort of a vacuum that's just limited to immigration. But there's this important interplay with so many government agencies, so many regimes governing what companies can do, where they can invest, and who can invest. And that's very important to know. So I really appreciate you joining us today.
My pleasure. Thanks for having me.
Thank you.